Losing a loved one is one of life's most difficult experiences, and amidst the grieving process, there are numerous practical matters that need attention. One crucial aspect is the disposition of remains, the process of handling a deceased person's body. In the state of California, specific laws govern how these matters are handled, ensuring dignity, respect, and adherence to the wishes of the deceased and their family. I'm Daniel Hunt, a certified specialist in estate planning, trust, and probate law, and in this video, we'll delve into the laws regarding disposition of remains in California. California has a well-established legal framework that governs the disposition of remains. The primary statutes relevant to this process are found in the California Health and Safety Code, particularly Sections 7100 through 7117. These laws outline the rights and responsibilities of individuals regarding the disposition of their own remains as well as those of their deceased relatives. One of the key aspects of the disposition of remains in California is determining who has the authority to make decisions regarding the deceased's final arrangements. The law provides a hierarchy of individuals who hold this authority. The order goes as follows: an agent under a power of attorney for healthcare or advanced healthcare directive, who has the right and duty of disposition; the competent surviving spouse; the sole surviving competent adult child of the decedent, or if there's more than one, then the majority of the surviving competent adult children. If there's not a majority but a reasonable effort has been made to notify all surviving competent adult children of the instructions and you are not aware of any opposition, then a minority of adult children can act as agents. The surviving competent parent or parents of the decedent. If one of the surviving competent parents is absent, the remaining parent must make a reasonable effort to locate the absent parent before acting as the agent. The sole surviving competent adult sibling of the decedent, or if there is more than one, the majority of the surviving competent adult siblings. If there's not a majority but a reasonable effort has been made to notify all surviving competent adult siblings. If there is not a majority but a reasonable effort has been made to notify all surviving competent adult siblings of the instructions and there is no known opposition, then a minority of siblings can act as agents. The surviving competent adult person or persons in the next degree of kinship, or if there is more than one person of the same degree of kinship, the majority of those persons. Less than a majority can also serve if a reasonable effort has been made to notify all persons of the same degree of kinship and there is no known opposition. If none of the above categories of kin are available, then a funeral director or cemetery authority can then act as agent for the disposition of remains. Note that a person cannot act as an agent for the disposition of remains if they have been charged with first or second degree murder or voluntary manslaughter. Family members may wonder who is responsible for paying the costs associated with the disposition of remains. California law states that the decedent's estate is liable for the reasonable costs associated with the mortuary and funeral services. California law recognizes several methods of disposition, including burial, cremation, and donation to science. Each method has its own set of requirements and considerations. Burial involves interring the body in a cemetery. Cremation entails the reduction of the body to ashes through intense heat. And donation to science involves donating the body to medical institutions for research and educational purposes. It's essential to understand the implications of each option and make an informed decision based on personal, religious, and cultural beliefs. California is a diverse state with people from various religious and cultural backgrounds, each with their own customs and traditions regarding death and burial. The law recognizes the importance of accommodating these diverse beliefs while also ensuring public health and safety. Individuals and families should be aware of how their religious and cultural practices align with California's legal requirements for the disposition of remains. Advanced planning for the disposition of remains is becoming increasingly common. Californians have the option to pre-arrange their funeral arrangements, specifying their preferences and relieving their loved ones of the burden of making decisions during a time of grief. Pre-planning can involve purchasing burial plots, selecting funeral services, and even prepaying for expenses. However, it's crucial to ensure that any pre-arrangements comply with California law and are properly documented to avoid complications later on. According to the California Health and Safety Code, Section 7100, a decedent, prior to death, may direct in writing the disposition of his or her remains and specify funeral goods and services to be provided. The law states that these directions may not be changed unless required by law, as long as the directions are unambiguous and arrangements for payment have been made. Now you may wonder, What happens if your agent fails to take action and makes decisions regarding the disposition of remains? If the agent fails to act or delegate authority to another person within 7 days from the date of the decedent's death, then their rights shall be relinquished and passed on to the person who is next closest in kinship to the decedent. For example, if the adult children fail to make any decisions regarding the disposition of their deceased parents' remains for over a week, then the decedent's living competent parents may step in to serve in this role. An exception to this general rule is granted to surviving spouses, who have a slightly longer period of 10 days to act before the control is relinquished to the person of the next degree of kinship. After waiting 7 or 10 days for the original agent to act, the person with the next degree of kinship can file a petition with the California Probate Court asking the court to release the decedent's remains to their control. If there are 2 individuals with equal rights to control the disposition of remains, such as 2 adult children of an unmarried parent who died without appointing a healthcare agent, then the funeral establishment or cemetery authority that's in possession of the remains can file a petition seeking a court order directing the proper disposition of these remains. When dealing with the immediate aftermath of a loved one's passing, an experienced trust and estate attorney can help ensure a smooth and dignified process. If you have any questions about the disposition of remains in California, feel free to contact our office. Thanks.